appeal of matter of Hargreaves Property Holdings Ltd and the Commissioners for His Majesty's Revenue and Customs.
Yes. Good morning, Mr. May.
May it please the court, I represent the appellant together with my learned colleague Dilpreet Danoa. Respondents are represented by Richard Ballat, KC, and Calypso Blanche. There are two grounds. I propose to take them one by one. And the decision that we're seeking, please, is one in principle only. The starting point is that the legislation, by and large, applies to both grounds. So I would propose to take you briefly to the legislation, which I'm sure you're very familiar with, and then I will move on to ground one. If I could ask you to turn to the bundle of authorities, please. And then to turn to tab 5. So I'll take through the legislation dealing with both grounds first. So starting with the top of page 18, this is just behind tab 5, you can see the section we're looking at is the Income Tax Act 2007, section 874, and you can see subsection 1, section applies if a payment of yearly interest arising in the UK is made. So pausing there, the second ground has to do with the meaning of yearly interest. Moving on to the first ground, as it were, is made by a company, that's paragraph A. And then subsection 2, the person by or through whom the payment is made must, on making the payment, deduct from it a sum representing income tax on it at the basic rate in force. And then if you see below subsection 3B, chapter 11, payments between companies, etc., gives a further exception from the duty to deduct under this section. That is the first ground. The first ground is by reference to that exception. If I could ask you to turn to page 20 within this bundle, please. You can see on page 20, this is the chapter 11 that was referred to. You can see we're talking about section 921 of the same act, the Income Tax Act 2007. And this chapter 11, makes provision allowing payments by companies to be paid gross in certain circumstances. Subsection 2, section 930, disapply specified duties, and the specified duties we'll see in a minute include the ones we've just looked at, to deduct where a payment is made by a company which reasonably believes that the payment is an accepted payment. And then if you look at subsection 5, sections 933, etc., make provision as to when a payment is an accepted payment. So if you then turn to the next page in the bundle, you can see that is section 930, and it confirms subsection 1, the duties to deduct sums representing income tax mentioned in subsection 2 do not apply if a payment is made by a company and at the time the payment is made, the company reasonably believes that it's an accepted payment. And then you can see subsection 2A, the duties to deduct include paragraph A, section 874, certain payments of yearly interest. And then if we turn to page 22, we get to what is effectively the key section for ground 1. This is section 933. A payment is an accepted payment if the person beneficially entitled to the income in respect to which the payment is made is a UK resident company. So that is, as is so often with these tax cases, it's just two words, beneficially entitled is the key word here. Now, when I was going through my speaking notes yesterday, I thought I would at this stage say what I consider the meaning of beneficially entitled is, since it lies at the heart of this appeal. And what I will do is give you my interpretation of the meaning, and then I'll take you to a case which is helpful on this point. So we start with the two words, beneficially and entitled. I hope this isn't too obvious, but entitled is a right to a thing. And we're going to see that from later cases like Khan and Good, which we'll come on to later. Beneficially entitled means, in my submission that you own it personally, i.e. that it's for yourself, you have the right to the interest. You don't hold it as a trustee, you don't hold it as a nominee. And as an aside, I've just looked at the expression beneficially entitled. When you receive in our case, interest, when you receive the interest in question, then in my submission, you will have beneficial ownership of the interest in question. So in a nutshell, beneficially entitled is a right to a thing that you have in your own name, which when you receive the thing, here interest, you will beneficially own. And the expression beneficially entitled here is used in my submission rather than beneficially owned, because we're looking to a future event. We're looking to a future receipt of interest. In other words, prior to the payment of the interest by the relevant payer, that payer needs to know whether they are obliged to deduct the duty of the income tax, or whether they're relieved from it by virtue of an accepted payment. So that it's by reference to the situation before the interest is received. Now, I think it might be useful if I just could take you to one of the cases which is helpful on this point, since this is a key expression. So if I could ask you to turn within this authorities bundle to tab 17. And as I say, I was going to tab 17, starting to read at page 228, is the Bupa case. If I can just very briefly give you the facts, which I think are fairly straightforward, actually. What you have is a group headed, you have a company, Bupa Finance, which has a subsidiary, Bupa Insurance. So they are like a little standalone mini group, if you like. And Bupa Finance acquires a company called CX Re. So, and it buys that from a company called, I think it's pronounced Tawa, T-A-W-A. So just pausing there, you have a relatively straightforward situation. I should have said actually, Bupa Finance acquired 46.18% of various shares. That figure is not relevant for the reasons I'll mention in a minute. But just so you end up with a situation where the top company for our purposes, Bupa Finance, wholly owned subsidiary Bupa Insurance, and Bupa Finance, the top company, has acquired a significant number of shares in CX Re. Now, what's rather odd about it is the price was £1 plus an earn-out consideration, and the earn-out consideration was calculated by reference to the dividends that Bupa Finance, which has just bought the A shares, would receive from CX Re, the target company, which it's bought as to 46.18%. So pausing there, you've got a situation where Bupa Finance is going to be entitled to distributions on the A shares it's acquired, and in addition, having paid only £1 for those shares, it has an obligation to pay earn-out consideration. And that earn-out consideration is circular, because what happens is that when a distribution is received from, calling it the target company, CX Re, then that informs the amount of the earn-out consideration, and immediately on receipt of the earn-out of that distribution, earn-out consideration is paid. Now, that sounds much more complicated than the actual question we're going to get, because the question is simply this. You have a situation where one of the companies within the Bupa group, Bupa Insurance, would like to access losses within the target company. And the question is whether it can do that pursuant to consortium tax relief. And it can do that missing an awful lot out if it has beneficial ownership of various assets. But for our purposes, the question is whether it was beneficially entitled to distributions.
Sorry, the question is whether Bupa Finance is
beneficially entitled, thank you.
Because if it is, Bupa Insurance can access.
That's exactly right, thank you very much. Yes, so that's it in a nutshell. Is Bupa Finance beneficially entitled to distributions from CX Re If it is, consortium relief is available to Bupa Insurance. And if you turn to the next page in this authorities bundle, page 229, and as I was doing this, with apologies, I didn't mark up the margin, but if I could just show you a helpful point from this page 229. So looking at the marginal notes, you can see between B and C, nearer to C, it says the contractual obligation to pay earn-out consideration was a mechanism whereby Bupa Finance passed the value of any distribution it received from CX Re, that's what I call the target, to TAWA. But the question was not whether Bupa Finance was commercially entitled to retain the distribution indefinitely. The statutory question, and this is important, was whether Bupa Finance had a beneficial entitlement to the distributions. And then there's a bit there which I don't think is particularly important, but if you go down 2 or 3 lines, accordingly, Bupa Finance had a beneficial entitlement to CX Re's distributions. Bupa Finance's contractual obligation to pay earn-out consideration did not deprive Bupa Finance of a beneficial entitlement to any distribution, actual or notional, made by CX Re for the purposes of the section. So just pausing there, you've got a situation where it's beneficially entitled to receive distributions because it's beneficially entitled to receive those distributions, and because the test is a beneficial entitlement, and I'll take you to a little more helpful wording in a minute. The consortium relief was available in respect of Bupa Insurance, the subsidiary of Bupa Finance. And what is interesting from the point of view of our case, because in our case you have a situation where interest is paid, I'll take you through this shortly, interest is paid to a UK company which immediately uses the bulk of that interest to pay the assignor of that interest, the consideration. So a company called Humet, using my figures, receives 100 and immediately pays 99 back by way of consideration for the 100. The question is whether in our case Humet has a beneficial entitlement to, in my example, the 100, given that it pays, in my example, 99 straight back by way of consideration. And what we say is that it does have a beneficial entitlement to that 100, even though it's paying, in my example, 99. I don't think my example is wildly out of the percentages we're talking about. So in this case, you have a situation where Bupa Finance receives a distribution, or its entitled distribution, and will then use that to pay the consideration for buying the target. And if you just turn over the page to page 230, you can see that I've marked there the first paragraph, which just confirms that the appeal concerns the meaning of beneficial entitlement. In particular, it concerns whether a corporate shareholder which receives a distribution on shares is deprived of a beneficial entitlement to the distribution by reason of a contractual obligation to pay equivalent sums to another party. And then if I could take you to 242, page 242, and with apologies, this is not marked again because I thought yesterday it'd be helpful to show you this because it's right on the point. So on page 242, I'm looking just over halfway down, under the heading, the features of beneficial ownership and beneficial entitlement. And those paragraphs 51 and 52 are useful. Would you like me to read them to you?
No, we can read that. Could I just interject, say, we're always grateful to the amount of work and time that goes into preparing papers for appeals of this sort, particularly as it has to be done both electronically and on paper. And I want to deliver a palm to whoever it is on this occasion, because the page numbers actually match as between the electronic and the and the paper. However, the authorities bundle is not OCR searchable,
Okay.
which means that it
Oh,
consumes a whole amount of of space in order to download it, and it means that I then can't mark it up. So just for future reference, for those who go to all this trouble, it would help if that could be done in future cases.
Thank you.
Thank you. Right, we're going to.
Yes, if you'd be
I'm
kind
going
enough
to
to
start
read.
reading 51 and 52. You say.
Yes, please.
Thank you. Yes.
Just to stop there, you can see at the end of 52, the Upper Tribunal says they will then give all sorts of examples. These are by and large by reference to cases which I'm going to take the court to later, so rather than ask you to read that out, I'll do that. The key points that I would ask you kindly to observe is that back on page 242, 3 or 4 lines down below H, the Upper Tribunal agrees with a submission that the reason that the draftsman used the term entitlement in relation to a notional profit distribution and to assets of the winding up rather than ownership is that the draftsman was in relation to profit distribution and notional winding up referring to notional future events, which is what that seems to me to be entirely correct. And then over the page, you can see at paragraph 52, the Upper Tribunal say that the term beneficial ownership has been described elsewhere as a term of legal art. And that's in the case IS, which I'm going to take you to. The fact that it's a term of legal art, it's not. The way I would put it is that it's a legal concept. And the reason I say that is because when we're going to look at the Ramsey principle, my submissions are that a term such as beneficial entitlement is a legal concept which is not readily susceptible to having a Ramsey approach which changes its meaning depending upon the circumstances.
This case, they go on to consider Ramsey. You going to take us to
yes. I'm going to consider Ramsey towards the end of my submissions, if that's
okay, but it's pertinent.
It's important, and one of the difficulties with this case, though, was that, as far as I can, at first instance, that whether there was tax avoidance wasn't raised.
I understand that.
Yes.
Just standing back, do you, in principle, accept that this statutory provision should be interpreted in accordance with the purposive interpretation?
Yes, I do.
Goes under the label Ramsey.
Yes, that's what I should have said. What I'm going to say is that it does have limitations, and that an expression such as beneficial entitlement is one that should not have dramatically different reasons, different construction, depending upon the circumstances. And my submission is that in this particular situation, the cases that we see, the IS case and wood preservation, Sainsbury, are good law for saying that beneficial entitlement has a particular meaning, which applies here. But I take the point that we have to apply the purposive approach.
Okay, but as I understand it, you're essentially saying, yes, apply a purposive approach, but the fact that the transaction with which we're concerned was undoubtedly tax motivated is not by itself enough, as the Ramsey cases tell us,
yes,
to put a different gloss, if you like, on the meaning as compared to what the cases you're taking us to would
Yes.
suggest.
That's my submission. Yes, thank you. Thank you. So whilst we're in the Bupa case, so that we don't have to keep referring back to it, can I now take you to the last page of the case, which is page 255. And page 2. The reason for mentioning this is that this is just to mention a different point that I'd like to make. I'd like to show you this now rather than us jumping backwards and forwards. One of the points is as to the meaning of the expression beneficial entitlement and beneficial ownership. And in the two appeals below, we focused on the Indofood case, both at the High Court, Chancery Division, and then in the Court of Appeal. And I'll take you to those cases briefly in a minute. But one of the points that arose was that the case had to do with a double tax treaty involving the Netherlands. And the question was whether, in relation to a double tax treaty, the expression beneficial entitlement and beneficial ownership should have a meaning by reference to domestic law, let's say that, for example, the United Kingdom law, English law, or whether it should have a treaty construction, particularly by reference to Indonesian law, because the case had to do with Indonesian law. And in the Chancery Division, it was held that you applied an English law definition of beneficial entitlement, and in the Court of Appeal, they applied an international fiscal definition. And in the Upper Tribunal, in this appeal, there was a suggestion, I think it's probably no more than that, that the First Tier Tribunal had made a mistake in this case in looking at the definition of beneficial ownership by reference to the Chancery Division decision, which of course is the English law decision. And just to put this point now, our submission is that the correct law to apply is the English law provision, which is the one that was used in the Chancery Division in Indofood rather than the one that was used in the Court of Appeal. And in this case, which we're looking at, the Bupa case, which is just an Upper Tribunal decision. But if you look at paragraph 94, you can see, which is marked, you can see towards the end below C, the parties agree that or actually I should take you a bit higher up, sorry, next to B. However, both parties agreed that Indofoods, by which they mean Court of Appeal, is not relevant to this appeal on the basis that the meaning ascribed to beneficial ownership by the Court of Appeal in Indofoods was an international fiscal meaning appropriate to double tax treaties. That was the Netherlands and Indonesia double tax treaty. So moving down here, the parties agreed that the authorities which had constructed beneficial ownership to which we referred, Wood Preservation, Ice and Sainsbury, which I'm going to mention, are undisturbed by Indofoods. So this is just simply going step by step. So what we say is beneficial entitlement is by reference to English law provisions. And then I'll take you to the English cases that in my submission are relevant. I should just show you the steps that were involved in this case as it will throw light on it. If I could ask you to turn to the supplementary bundle. So if you turn please to tab 1, you can see behind tab 1 there's a facility letter, and it's between a lender, Richard Andrew, and the appellant, who's the borrower, Hargreaves. And then you can see that it's, from the subheading, it's a revolving loan facility. And then you can see that, wholly unsurprisingly, the purpose of the loan general business purposes. There's a drawdown provision, interest provision, and so on. So this is a general facility letter. If I could then ask you to turn to tab 2, you can see at tab 2 on the 11th of March 2013, you have an agreement between Richard Andrew, whom we've just looked at, Storier Trading, which is a company which is resident in Guernsey, which is the purchaser or assignee, I would say, and then you've got the debtor, which is the appellant, which is the original borrower. If you look at recital A, you can see the debtor is indebted to the vendor in the sum of just over £2 million. You can see that the principal was 1.975 million, and you can see the interest of 36,000 plus has arisen. And then you can see from recital B that the vendors agreed with the purchaser for the sale of the debt, the capital borrowed, and all rights and benefits, and the right to future interest for a price of just over £2 million.
The wording of clause 1 suggests that the assignment consideration is paid at least no later than the date of the assignment.
Yes, I think you'll see that the dates are the documents which come up.
But I'm not sure we've got very clear FTT findings.
That's true. We haven't. We haven't. What we've got, where the FTT didn't have evidence, was I think precisely the payments that happened between Humit and Storier, precisely. But I'll take you to what we do have.
Thank you.
But I'll show you what we do have.
Yeah.
If we then go to tab 3, you can see tab 3 follows on, and this is because we've just seen that Storier has just acquired the capital and the interest. And then you can see on the same day, Storier is stating in the letter which it has sent to the appellant, you can see from the main heading, notification of assignment of right to receive accrued and future interest. You can see that it says we give notice that Storier have assigned all our rights to receive interest in respect of a debt in principle of 8.8 million. So this is a total debt by virtue of 6 instruments of assignment, one of which we've seen, to a company, Humit Limited, which is a company incorporated in the UK, but it's tax resident therefore in the UK, but it's controlled and managed in Guernsey. So this is effectively an assignment of interest, or notification of an assignment of interest. So so far we've seen the capital interest passed to Storier, and Storier has now, in respect of its right to receive interest from the appellant, it's now notifying Hargreaves that it's assigned that right to receive the interest to Humit. And then if you look at the next one behind tab 4, you can see that this is refers to a letter which has been issued by Storier that in relation to accrued interest on the loan of 1.975, that was the original loan which I took the court to, the benefit of interest there has been assigned to Humit, and you can see from the second paragraph there's a request that payment of the accrued interest of just over £37,000 should be paid. And then finally you can see behind tab 5, just to complete the picture, this isn't particularly relevant to this appeal, but just to complete the picture, you can see there's a letter from Storier to Hargreaves requesting payment of the principal sum of £1.975 million, the interest having already been assigned to Humit. So you can see from that that there's a assignment of capital and interest to Storier, followed by a further assignment of the interest from Storier to Humet, and Humet receives the interest of about 36,000. And in the first tier tribunal, it was held that in this example, £36,000 had been received by Humet, but there was they did not, the first tier tribunal did not accept that the 36,000 had been was beneficially entitled in the hands of Humet, because the vast majority of those amounts were used to pay the consideration for the interest. That's where I got my notional figures of. If you say the interest is 100, and you pay, Humet effectively paid 99 from what we could, from the facts that we have received.
So just so I understand, the interest is money is lent to your client, interest is paid on that money, and tax is due on that interest.
When paid abroad, yes. When paid, yes.
Well, tax is due
yes.
in the end, wherever.
Yes, yes.
But who pays the tax?
Well, in that situation, it should be paid by the recipient of the interest.
Yeah, but in this instance, who
it
pays
should be
the
paid
tax?
by Humet.
Right. And is it paid by Humet?
I don't know. We don't have information. I don't know.
And
It certainly should be.
and is Humet in a position to pay tax of this amount? Or is that no concern of your client?
Well, obviously, it is a concern, but I suppose our client would say it's not strictly speaking a concern, because its concern is to make sure it complies with its.
The only concern of your client is just to push it off.
The concern of the client is to make sure that it, in relation to its obligation under 874, to see whether it's an accepted
your
payment.
client, this being the result of trading in property in this country.
Yes, that's right. So that's what the position is, whether 874 is engaged. We say that we accept it is engaged, and then the question is whether the accepted payment rate.
Yes, but I'm just starting from the position that tax is owed on this interest.
Yes.
Appreciate your narrow concern is to try and achieve a situation where it isn't payable by your client.
Yes.
But so that I can understand what the scheme amounts to. Your case is that the taxman should be knocking at the door of Humet, is that it?
Yes, and it's a UK tax resident company. So for those, although it's based in Guernsey, it's incorporated in the UK.
Right, and that the amounts involved over this 5-year period nearly 3 million.
Yes.
And that they should have been looking to Humet for those amounts, or Storio, the person for part of it.
Yes, that would be the answer. Yes, but yes.
Remind me, Storio is not resident.
It's resident in Guernsey.
It's not resident in UK.
No.
Mr. Ware, this is potentially relevant to the proper interpretation of these code of rules. The authorities bundle doesn't include the whole of the chapter that provides for accepted payments. But it does seem to be potentially relevant that the list of entities to whom payments can be made gross include, in the case of companies, UK resident companies and UK branches of non-resident companies. You haven't included that in the bundle, but I've taken the liberty of reminding myself. Now, it seems if one asks yourself what is the aim of that, we haven't also been given much help in that, and there are, in fact, those provisions were originally introduced in 2001, and there is some material available in relation to their introduction. But just sticking with the legislation and the framework of how the tax system works, one point to note is that both UK resident companies and UK branches of non-resident companies are within the charge to corporation tax. So as my lord says, a recipient of that interest should be bringing it into account for tax purposes. And maybe in that context, it's a bit less surprising that the revenue of Parliament may decide that there should not be a withholding tax requirement, because the recipient is in the jurisdiction and within the charge to tax. Also, as I understand it, you maintain that broadly beneficially entitled means someone is not a fiduciary. If they were, as I understand it, corporation tax, they wouldn't be within the scope of corporation tax. So I just wondered if you and Mr. Vallet in due course could bear those comments in mind when you make your submissions.
Yes, thank you. Yes, I mean, I would say Humet is a UK tax resident company because of its incorporation, and therefore it is within the charge to corporation tax by virtue of that.
It's dissolved in 2018.
So that's irrelevant.
Picked up that it had been dissolved, but that's not.
Yes, I'm not sure
that's
that's
not
relevant.
Determinative of our, what
no.
we have to decide.
I don't know, it's dissolved after the effect. I don't think that's determinative. No. So
Can I just check? You've shown us various documents. We don't see in these documents what the price payable by Humet to Storier for the assignment of the coupon was.
no.
But you said it was 99% of what it received.
Yes.
Do we have findings of fact? To
Yes,
that
I can.
effect?
Let me see if I can quickly show you those.
Thank you.
Yeah. If I could ask you to turn to the core bundle.
Yes.
To tab 9.
Page? What
And
page?
then. Yeah. And
What
then
page, please?
Page 132.
Thank you very much.
This is the FTT decision.
Yes. If I look at the bottom of page 131, actually, you can see the FTT say at the bottom, Appellant satisfy me the interest paid to Humet was not received by Humet as nominee or trustee. This leads to my concluding that Humet did have beneficial entitlement to such part of each interest payment made to Humet in the 4 financial years in question as exceeded the amount paid by Humet to Story or the relevant Guernsey Trust. There was for the right to receive the interest payment. I'm content to leave it to the party to calculate how much. Then you can see, however, I would note such evidence as I have indicates the amount in question likely to be extremely small or perhaps even nil. So you can see, for example, the aggregate difference appears to be 500. You can see, so there's an example, 755, 773 minus 755, 273 in respect to the financial year, 31st December 2012, and so on.
Do we actually have a any earlier finding of fact that Humet used the money received to pay for the assignment, or do we not have that? Because certain documents you've taken.
Yes, I'm just trying to find the bit in this decision the where they talk about the accounts. Let me just see if I can find that.
Is 137, paragraph 137, sort of in the area that you're...
Yes, that's it. Thank you. Yes, that's what we have. Yeah. So you can see 137 for a financial year ended 31st December 2015. You can see for the financial year revenue of just under 3 million, cost of sales more or less the same, and a gross profit of just under 1,000. Yes, what I was trying to remember was paragraph 138, which is where the relevant accounts showed that sums had been received and then paid away.
Okay, so that's what we have.
Yes.
Thank you.
Sorry, I'm just...
So if I could now just quickly take you to Indofood very briefly, because I think I'm sure you have the point I'm making. So this is in the authorities bundle behind tab 15. Would you like the page number? Is that right? So that's page 187. The facts are relatively straightforward. You have a situation where you have an Indonesian company which is paying interest to a Mauritian company, and then following various changes in the relevant double tax treaty, it's decided to improve the position from a tax point of view by interposing between the Mauritian company, which is due the interest, and the Indonesian company, which is paying the interest, a Netherlands company, which will receive the interest and pay it on. And the question was whether, in those circumstances, the Netherlands company had the benefit of the relevant double tax treaty between Netherlands and Indonesia. And it would have that if the Netherlands company, which was interposed to receive and pass on the interest, had beneficial ownership or was beneficially entitled to the various interest payments. And if you look at the bottom of page 187 where it says held, and bear in mind this decision is about to be overturned by the Court of Appeal, it says that the question of whether the Indonesian company would be eligible to receive the benefits conferred by the Indonesian-Netherlands double tax agreement depending on whether the Netherlands resident company would be beneficially entitled to the interest payable to it by the Indonesian company within the meaning of the double tax agreement. And then if you look a few lines down, the mere fact that an entity was a conduit did not mean it was not the beneficial owner. And then if you turn to page 195, you can see at paragraph 24 This is the decision of the judge, Mr. Justice Evans Long. Paragraph 24, in deciding whether the proviso permits the trustee to decline permission, etc., I've given a firm view as to how I have to form a view as to how the Indonesian tax authorities will react to the proposed restructuring if it is put into effect. And since this involves taking a view on the likely decision of another court, namely the Indonesian tax court, this is an unusual role for a British judge. And then if I turn to 201, page 201, paragraph 46, it's clear that NUCO will not be a nominee or agent for any other party, and not being any sort of trustee or fiduciary will have power to dispose of the interest when received as it wishes, although it will be constrained by its contractual obligations to the issuer to apply the proceeds of the interest payments in performance of those obligations. And then if I could ask you to turn over the page to page 202, and I'm looking at the middle of paragraph 50. In the middle of paragraph 50, about 6 or 7 lines down, it says, in no sense will NUCO be acting as nominee or administrator for the issuer or the note holder. It will merely be contractually bound to indemnify the issuer against its obligations. And then a few lines down, just between D and E, after restructuring, there will have to be some entity that qualifies as beneficial owner of the interest. It seems to me there will only be one candidate for the namely NUCO. In fact, if one is considering the substance of NUCO as beneficial owner, his position is stronger than that of the issuer. So that's, as I said, this is about to be overturned, but it's relevant because it was at first instance in our case, it was held that the English law approach to beneficial ownership was correct. So just to complete the picture, if I could ask you to turn to the next tab, and that's tab 16, page 205. I think actually I can really speed this up. If I could ask you to turn to page 218. And we're looking at the Court of Appeal judgment, page 218, the bottom of the marking, just by paragraph E, missing a lot of the other markings out. We can go straight to this. This is the indent just before F. This suggests that the term should be accorded an international fiscal meaning, not derived from the domestic laws of contracting states. So I don't think I need to show any more. It's just to demonstrate that the purpose of approach has to be applied. In the Upper Tribunal, in our case, it was said that Indo-food, it was perhaps this is too harsh, or perhaps the wrong gloss on it, that we shouldn't be looking at Indo-food in the Chancery Division, but we should be looking at Indo-food for its purpose of approach. My submission, we should be looking at the domestic meaning of beneficial entitlement, which is found by reference to Indo-food in the Chancery Division, but we should be applying a purpose of approach as well. So I think that's where perhaps we tidy up what should have been said in my respectful submissions in the Upper Tribunal decision. So the next case to go to is the wood preservation case. This is behind tab 8. I'll just give you the page number. So this is page 24 of the authorities. So again, this is a relatively simple case that I think I can explain I'm sure you know it already, but let's just explain quickly. You have a company called, if I'm pronouncing it right, Silexine, S-I-L-E-I-X-I-N-E, Silexine Paints, which is the 75%, which owns beneficially 75% shares in the Appellant company, Wood Preservation Limited. There's an unconditional contract to sell all of that shareholding in wood preservation to a third party. And after the unconditional contract has been entered into, but before completion of the contract, wood preservation seeks to make use of the losses within what was its previous parent, within Silexene. And so the question is whether those losses can be accessed, and they can only be accessed if loss relief is available, which will require that company, Silexene, to remain the beneficial owner of the shares in wood preservation. The question is whether the entering into the unconditional contract, albeit it hadn't been completed, would deprive Silexene of beneficial ownership of the shares. And the answer was that it did deprive the company from beneficial ownership because beneficial ownership means, in this case, the right to deal with property as one's own. After entering into the contract, the relevant company had no power to deal in that way, and this can be quite quickly found at page 43. So page 43, you can see marked paragraph C. We're looking at Lord Donovan judgment. But if one finds us here that the company which made the losses, though still the legal owner of the shares, is bereft of the rights of selling or disposing or enjoying the fruits of those shares, then bearing in mind the relevant section, it would be a misuse of language to say it remained the beneficial owner. So that's fairly straightforward. That's just another example where beneficial ownership is lost. The next case to look at is Sainsbury, and I'm just picking up from the cases that Bupa has mentioned were relevant and which I think are good examples of the way the English law has looked at beneficial ownership, beneficial entitlement. So this is behind tab 11, page 101. So again, this is a relatively straightforward case. You have a situation where Sainsbury's and a Belgian company enter into a new joint venture company to be called Homebase. And the original agreement between those two shareholders, Sainsbury's on the one hand and the Belgian company on the other, was that Sainsbury's would take 70% of the beneficial ownership, as it were, of Homebase, and the Belgian company would take the remaining 30%. The problem with that was that denied Sainsbury's various tax reliefs which it needed, which were only available to it if it had, rather than 70%, it had 75%. And so it was agreed that an additional 5% of the shares in Homebase would be issued to Sainsbury's, so that following that issue it would be 75-25 rather than 70-30. But to protect the position between the parties from a commercial point of view, put and call options were entered into over that 5% shareholding. So you end up with a situation where you have a 75% shareholding in the hands of Sainsbury's,
of which 5% has just been parked.
Yeah, but it's subject to the put and call option over 5% of its shares, or the 5% shareholding. So the question is whether it was beneficially entitled to 75% or 70%.
Yeah, I think, as I recall, the terms of the put and calls actually would economically synthesise the intended 70-30.
Right, that's helpful. Thank you.
I think that's the case.
Well, that's helpful. I missed that. Thank you. I should remember that. That would make it more extreme, wouldn't it? But anyway.
But I may be wrong.
I wonder if I could just see if I can quickly find that.
Economically
Reproduce
synthesized.
the.
I don't think I'm going to find that quickly, so if it's relevant, I can come back to it. So if I could ask you just to turn to page 116. So the question is whether the option deprives the option over the 5% shareholding deprives the means that you don't have beneficial ownership of that 5% as well as the other 70. Thank you. So looking at page 116 at the top, you can see that here's Lord Justice Norse. You can see he says, although he might not agree with Lord Diplock, although I might not with Lord Dip have gone so far as to think the expression beneficial ownership is a term of art, it's certainly one which for several centuries has had a very well recognised meaning amongst property lawyers. So we say that's a relevant point in determining its meaning, the fact that it is an expression which may or may not be a term of art, but we say it's a legal concept. And then it's quite helpful towards the bottom of that first paragraph because it confirms what I consider the correct position as to the meaning of beneficial ownership rather than just ownership. So the last sentence of paragraph C, thus to take the simplest case of divided ownership to which the section can apply, if Company A is the registered holder of shares in Company B as a nominee, i.e. as a bare trustee for Company C, the beneficial ownership of the shares is C, which seems to me to be straightforward. The reason I'm labouring the point is we'll see later on, when we come to some of the other cases, a discussion as to what entitlement means and whether in tax terms entitlement means has to be beneficial entitlement or just entitlement. And there's a suggestion, I may be misreading it, that perhaps beneficial entitlement means that you can benefit from it, from the entitlement.
Yeah. Okay. Just to answer my earlier point, I think if you go to page 114 at the top, it tells you what the option price was, which was the amount paid for the shares plus interest less the amount of dividends paid. So it's
yes, so economically, as you've kindly said, it is
yes.
It takes you back to 70/30. Yeah, thank you.
Is what is said at page 116, which was where we were a moment ago, is that the same as what Lord Donovan was saying at page 43? What I noted down amongst the things that he was saying was no power to deal as one's own.
Yes.
It seems to be a rather more everyday analysis than what we're looking at page 116.
Yes.
Are they saying the same thing?
But were you looking at wood preservation?
Yes, sorry.
Yes. No, it's all right. Sorry.
Too.
Yes, the wood preservation.
Yes.
It's that, I mean, they're looking at, yeah, you're ahead of me, of course. They're looking at slightly different things, aren't they? But it's the same. One is saying you've lost everything, therefore you've got no power to deal, as you just said, therefore you can't have beneficial ownership. Whereas this one is saying that, I suppose, that if you retain, in a way, if you retain these or can demonstrate these ownership qualities, then that goes to beneficial ownership.
But this paragraph on 116 appears to be a more classical sort of trusts analysis of the situation.
I would say
in comparison to wood preservation, but
I would say they have equal status actually, but that's what I would say. But I think classically one would perhaps be looking at classically I don't think this makes much difference, so with apologies, but with beneficial ownership, classically one would say you're looking at ownership for one's benefit, for one's in one's own name.
There must be a difference, because one can own things but not have the sense of the power to deal with it as if it was one's own.
Yes. So once
because one was tied up by various other obligations.
Yes. So, but I think what we're saying is that what we're going to say is that if you have an obligation to make payments out of receipts, that does not deny you have beneficial ownership of the receipt. So if you look at the case of Indo Food of first instance, under an English law, meaning the fact that the Netherlands company received interest and was obliged to pay it on, did not mean that it was denied that it no longer had entitlement to that money. It had entitlement, and then it then paid from its own entitled sums, its own beneficial ownership. It paid sums on. So my submission is it is a fundamental English principle that you are allowed to receive sums, and even if you're contractually bound to pay them on, you can still be, obviously you are still beneficially entitled to those sums. The question is whether, as in wood preservation, you've actually broken the knot, you no longer have that right.
Well, the analogy with wood preservation would be that you're not only contractually obliged to pay on that sum, or maybe a sum equivalent to it, but you've also effectively transferred your right to that sum, at least beneficially, or so tied it up
That's right, in wood preservation,
use
yes.
it for your own purposes,
Yes, whereas
including to meet your own obligations.
if that has happened, yes, if you've given that all away, yes. But I'm sure you're ahead of me. If you've retained beneficial ownership, it's not denied by the fact that sums to which you're beneficially entitled come in, and you then pay those sums out by reference to contractual obligations. You still have a beneficial entitlement to those monies, and we'll see from the cases we're going to look at that entitlement in a modern day context includes that concept. That just because you are using sums, say, to discharge the obligations to a lender, that does not deny you have beneficial entitlement. Over the page to page 117, just quickly, you can see at the bottom, I think it's just quite helpful that it ties in with wood preservation just being mentioned. So the bit that's marked, or the decision of this court in wood preservation is binding on us. I'd be unwilling to apply it to any case where the vendor retained more than a mere legal shell of ownership. The grant of an option which has not been exercised retains much more than that. For the reasons given below, I agree that within the meaning of the section, the beneficial ownership in the 5% of the shares was vested in the taxpayer company. So the next case to look at is at tab 9, which is page 45. And this is again quite a straightforward case as far as the facts are concerned. You can see that the appellant is C&K Construction Limited. C&K Construction Limited had been the subsidiary of a company called MacTrac, M-A-C-T-R-A-C. MacTrac then went into commenced winding up. So MacTrac is the beneficial owner of effectively all of the shares. It then starts a winding up, and then it seeks to transfer its business down to what we now know was its subsidiary. So the question is, if you have a business in a top company, the top company then commences a winding up. The top company then transfers its business to, quote, the subsidiary, unquote. Is the subsidiary, as you know, it's still a subsidiary for tax purposes, bearing in mind that winding up has commenced. So the real question is, does winding up mean that beneficial ownership ceases on that event? And the short answer is that it does. Because once beneficial ownership commenced, and once winding up commenced, beneficial ownership of the assets was lost. And I think we can just quickly find that at para 50. Page 58, sorry. At the bottom of page 58, you can see, I just was looking at this yesterday, but it goes on to bits that are marked, but it's quite helpful at the bottom of page 58, paragraph G. My lord's expression beneficial owner in relation to the proprietary interests of a company and its assets was first used in a taxing statute in 1927. And then over the page, you can see at the top of page 59, it can be inferred a recognition by Parliament that when a company is in liquidation, it ceases to be the beneficial owner of its assets within the meaning of that expression, and then the marked paragraphs there, beneficial and beneficial ownership, appear in Finance Act 1930, and then looking to the paragraph below, the final main paragraph. So when these words were repeated in the Finance Act 1954, not only was there consistent line of judicial authority that upon going to liquidation, a company ceases to be a beneficial owner, but also there's been a consistent use in taxing statutes of the expression beneficial owner and beneficial ownership. So again, this was one of the points to make, that this expression has had a consistent meaning for quite some time. Beneficial ownership, we would say effectively beneficial entitlement, have a consistent meaning. If I can now take you to a recent case, which is the case of Khan. You can find this behind tab 21. Appreciate this would be familiar. This is a familiar case. So I'll just explain the facts as best I can. So you have a company which was called Computer Aided Design, and that company had 3 shareholders, and it had distributable reserves of £1.95 million.
Say that again, sorry.
Distributable reserves of 1.95 million. And on top of that, it had a net book value of £18,771. So the 3 shareholders were content to effectively get rid of the company, and the original idea had been to effectively extract the reserves themselves, and the appellant here, Mr. Khan, would then take over the company, which had a net book value of 18,000 plus. But what they decided to do, and I'm not sure that the case tells us why, they decided to enter into, I don't know whether it was a scheme or anything, but they took the following steps. What was agreed was the company would lend Mr. Khan £1.95 million. He would then buy the shares from the 3 shareholders for a consideration of the 1.95 million, which was the value of the reserves, plus the extra amount, 18,771. Having done that, the 3 shareholders would have departed. They'd have received their 1.95 plus the 18,000. And what would happen then would be that he would become the sole shareholder of the company, and then the company would buy back his share. He had 1 share in the company for £1.95 million. And so what you had there was a situation where instead of his just paying consideration away to the third parties and receiving shares, instead he becomes a shareholder, and the company then buys back his own share for 1.95 million, which he uses to pay off the sums he's borrowed in the first place to buy the shares. And he borrowed those sums from the company itself, so he just simply, there's a setting off against on the buyback, there's a set off of the 1.95 that's due to him against the 1.95 he's due to pay to the company. So the question, and you can see this on page 331, the question is whether the taxpayer, Mr. Khan, should be taxed on a receipt of £1.95 million or not. And if you look at the page 331 towards the bottom of the head note, just against paragraph G, it tells us the taxpayer appealed, contending that since he'd been bound to use the share buyback proceeds to repay the loan, he had neither had control over nor benefited from those proceeds, and that consequently he could not be said to be the person receiving or entitled to them. Those persons, so the taxpayer argued, were the shareholders. And then, if you just look over the page to page 332, you can see between paragraphs B and C, there's a helpful wording in the headnote. It just says, just below B, 2 lines below B, the concept of receipt of a distribution did not contain an implicit requirement that the person who received the distribution also had practical control over it, and being entitled to a distribution meant no more than having the right to the distribution, and contained no implicit requirement of benefit, so that on the facts of the present case, the taxpayer had been entitled to and had received a distribution for tax purposes. Then it goes on to say, in particular, the fact that following the share sale and buyback transaction, the taxpayer had ended up as the owner of the company's sole remaining share at a modest personal outlay with the shareholders, effectively made no difference effectively. In other words, the question was whether, in that situation where there was a plan by which 1.95 would be borrowed from the company, would be paid to the selling shareholders. The individual would then become a shareholder, receive 1.95 on the buyback of his shares, which was that 1.95 being offset completely by the obligation to repay the loan. Could it be said that he was received, and for our purposes, entitled to 1.95, or could you ignore the fact that there was an obligation to pay a loan, and it was held that he had been received and had been entitled to the monies?
Reference further down to the genuine role played by the taxpayer. This was a case where he had been the company accountant.
Thank you. Yes. Mr. Khan was the company accountant. Yes, thank you. If I could just take to page 335. We've got the in the authorities bundle. We've got the elsewhere. We've got the section, but it's helpful to look at it now. You can see against paragraph 6 at the top of page 335. You can see the relevant section number 385, and you can see on the indent the person liable for any tax is the person to whom the distribution is made, etc., or B, the person receiving or entitled to the distribution. So the case revolves around the meaning of received or entitled to the distribution. You can see over the page 336, there's a paragraph 11 which states that Mr. Bradley, who appeared for HMRC, rightly accepted that the expression receiving or entitled to must be given a consistent meaning in its where, which we say is important. And then if you go to page 343, you've got there paragraphs 49 and 50. You've got a discussion as to the meaning of receipt or entitlement, and you've got this reference to the Ramsey approach, what you might call the purposive approach. And you can see that, as we've been discussing briefly, in the middle of paragraph 49, established that the factual analysis depended on the purposive construction of the statute. The ultimate question was whether the relevant statutory provisions construed purposively were intended to apply to the transaction viewed realistically. And then you've got Lord Reed's comments. which just says it might be said the transaction must always be viewed realistically if the alternative is to view them unrealistically. The point is that the facts must be analysed in the light of the statute provision being applied. If a fact is of no relevance to the application of the statute, then it can be disregarded for that purpose. If, as in Ramsey, the relevant fact is that the overall economic outcome of a series of commercially linked transactions, then that is the fact upon which it is necessary to focus. And then if, on the other hand, the legislation requires the court to focus on a specific transaction, as in McNiven and Barclays, then other transactions, although related, are unrelated to have any bearing on its application. So on that basis, what I would say this case is showing us is that although there was a scheme, you ignore the various steps that were taken, and you just focus on whether there's been a distribution. But what I would say as well is there's a reference there to McNiven and Barclays, and I'm going to take the court to McNiven because that is relevant in our submissions in relation to the times when you have to be cautious in applying a purposive approach. If you look at the foot of page, the next page, 344, and then you say it says that in paragraph 54, the matters considered by the Upper Tribunal did support their interpretation of the section, that irrespective of actual receipt, the person entitled to the distribution is the person to whom the distribution belongs. That interpretation is also consistent with the approach taken by the court in the Timpsons and Yerbury case. The focus of the court's concern in that case was not on Mrs. Timpson's power to direct the trustee what to do with the money, but rather on whether she'd exercise that power in a way that meant that at the time when the money came within the jurisdiction and prior to actual payment, it belonged to one of her children. This wasn't so because Mrs. Timpson could have revoked her instructions at any time.
Before we leave that page, what would you say about 51?
Let me just read that.
Yeah.
Yes, as you know, what that is saying is that it's unusual for a taxpayer to rely on Ramsey.
Yes.
But thank you. But the principles in Ramsey are of general application, and our focus must be on whether the Upper Tribunal erred in refusing to look at the sale.
It was really the bit in the middle of that I was pointing to, which I just wondered what you would say, because it seems to link with the genuine role point.
Yes.
That was raised that this was not a scheme.
Yes.
That was going on in Khan.
I think that's fair enough, yes. I think, yes, I take the point. I mean, it doesn't look like a scheme, does it? It just looks like a mistake, frankly.
Evidently a scheme from the point of view of the selling shareholders.
I didn't hear that, sorry.
Evidently a scheme from the point of view of the selling shareholders, because they'd worked out that if they received a buyback distribution direct, they would have paid tax on it.
I see, yes, yes.
So
yes.
there was a scheme.
Yes, thank you.
Whether Mr. Khan was an
I
unwitting
see.
participant.
It wasn't a scheme to benefit Mr. Khan, yes. Thank you. Yes, that's helpful. So,
thank you.
That is most helpful, thank you. Then over the page 345, which I think is just that it's considered that the Upper Tribunal correctly identified the purpose of the section and interpreted it. It's concerned with the person who actually receives the distribution, and if different the person to whom the distribution belongs, they were one and the same. So what I would say is that even though there was a scheme, the scheme was effectively ignored, and you just looked at what had actually happened as a matter of fact. So you looked at the fact that a distribution had been received by Mr. Khan, and even though under the terms of the scheme, as has been said, there was to be a benefit to the outgoing shareholders, you could still say that within the terms of the scheme, there was to be an offsetting in Mr. Khan's hands of the obligation to pay the loan. that was all ignored. You just looked and said, well, what actually did happen is that there was a receipt, and on that basis, tax arose.
The expression that's being construed here is slightly different. In it's
Yes.
entitled to.
Yes.
Rather than what we have, which is beneficially entitled. And one of the points that you've taken us to in this is that benefit was not a.
Yes. I mean, the point I'd make about that is that in my submission, if somebody is beneficially entitled, they have to be entitled in the first place. So if they're not so that therefore there is some learning to be obtained from cases such as this as to the meaning of one of the two words in that expression, and therefore my submission would be that entitled has a wide meaning. The expression beneficially in that example it means for one's own benefit, not held as a nominee or a trustee. So my submission is that the case of Khan is of assistance in demonstrating that the word entitlement has a wide meaning, and it does so in my submission within the well-known expression beneficially entitled. In my view, entitled is the same in both of those. It's just a question of whether it's beneficially entitled. If I could take you to page 351. Page 351, just quickly finish off, I've made this point already, but the marked point against paragraph 81, you can see it's stated correctly, obviously. The fact that the payment of the distribution was made by way of set-off against the liability to repay the loan does not mean there's no receipt. Mr. Khan was derived a real benefit from the payment because it extinguishes corresponding liability to pay the loan. It's not a case whether he was acting, where this was not a case in which Mr. Khan's interest in the money could be described as a mere legal shell. And if you look at the other marked paragraph below, which is against paragraph 83, what's said here is entitlement means no more than having the right to the taxable income, in this case the distribution. And there's no further implicit requirement of benefit in the sense used in the group or consortium relief tax cases. If one asks the only pertinent question, to whom did the purchase price of the shares belong, there's only one answer, Mr. Khan. However, even if there had been a requirement to benefit, Mr. Khan did benefit from the distribution, as it was held that the fact that he was entitled to and did receive the distribution enabled him to discharge the amounts. Now, what I would say is obviously here the expression benefit is looking at, I suppose, an entitlement with a benefit. And what I'm saying is beneficial entitlement is, in my view, slightly different. And in my view, beneficial entitlement is a bit like a beneficial ownership, or who is the person who actually, as a matter of law, owns in real terms the asset or has the entitlement to the asset. That's why a nominee wouldn't count and a trustee wouldn't count. So in my submission, beneficial entitlement is simply entitlement with the word beneficial meaning that it's for the purpose, for the person in question's own use, not as a nominee. So this is why we say this case is helpful in showing that the expression entitlement has a wide meaning, including a distribution where it's not actually physically paid, I don't think, into Mr. Khan's bank account, but in any case, it's immediately paid away to discharge the loan. The next case to look at, please, is the case of Good, which is behind tab 23, page 383. this is a film scheme, and the facts are quite complicated, but I think one can make them really quite simple. Missing an awful lot out. Mr. Good borrows a significant amount of money, 79% of the price of the amounts that he needs. And he puts up the remaining 21% that he needs from his own resources. So he borrows 79%. With the 100%, he then acquires distribution rights to 2 films. So he's bought distribution rights to 2 films, and he's borrowed 79% of the price. The next thing is that he then sells those distribution rights to a purchaser, and the price that he gets back is in 2 forms. One, it's a share of the receipts which the purchasing company will make from exploiting the film, so a share of the royalties. But the key to our case is that in addition, he gets something called minimum annual payments. And in the case, they're called MAP, M-A-P, minimum annual payments. And these are stated just to be enough to enable Mr. Good to meet the interest payments which are due on the loan which he took out in the first place to buy the rights. But at the same time as this is all going on, so at the same time as he sells the film rights to the third-party purchaser and receives the right to the receipts and the minimum annual payments, he assigns the minimum annual payments to the original lender. And so, in a nutshell, reducing very, the facts to their minimum, the question was simply, if you are entitled to payments from a purchaser, and if you have an obligation to pay a lender, and you assign your rights to those payments directly to the lender, and those payments are used from time to time to discharge your loan, effectively, are you entitled to those payments? The taxpayer would try to say no, because the taxpayer said he wasn't entitled to them because he never received them, because they went directly from the purchaser of the film to the lender. So the question was whether in those circumstances Mr. Good was still entitled to the monies, because if he was, he had to pay tax on those amounts, and it was held that he was entitled. If the simplest thing to sort of show that, if you look at page 383, in the head note towards the bottom, just above letter F, you can see it says 2 lines up from letter F, the revenue issued discovery assessments against the taxpayer on the basis that he was liable to pay income tax on the minimum annual payments pursuant to the legislation, since the maps constituted income from a business involving the exploitation of films to which the taxpayer was entitled within section 611. It made its way to the Court of Appeal, and you can see it was held on a purposive reading of section 611. The focus had to be on the particular transaction giving rise to the income in question, and not any connected transactions considered as a composite whole. That further, the words entitled to were words of ordinary usage, which should be given their ordinary, non-technical meaning, and thus entitled to for the purpose of section 611 was wider than received, did not mean belong to, and did not import the domestic law concept of beneficial interest or entitlement. Now we'll come on to that in a minute, because what I agree that it's a different expression from beneficial entitlement, but in my submission, entitlement within the expression beneficial entitlement is the same as entitlement generally. It is the right to something, and the beneficial quality is that it's for your own benefit. If it's in your own ownership. So what I would say, and I'll come on to this later, is that this case is helpful in demonstrating that entitlement within the expression beneficial entitlement has a wide meaning.
It is your essential submission that in what we have to interpret beneficially adds nothing.
Beneficial entitlement, yeah.
But I mean,
Sorry, beneficial
beneficially entitled,
Yes,
which
sorry.
are our words.
Yes, I beg your
But
pardon.
your essential submission in this context is that, I mean, beneficial is an ordinary word, but that actually it adds nothing to entitled.
Yes, and I would say that often in tax legislation, the words like entitlement and so on are always, or not always, are by reference to beneficial entitlement. That would be my submission. But that is my submission. Yes, thank you. That's much better put than I did. Thank you. If I could take you to page 386. This is just to show you the section. So if you look at page 386, the marked paragraph, you can just see, we're looking at the section 611 of Itoya, and it just says at the bottom of that marking, the person liable for any tax charged is the person receiving or entitled to the income. If I then take you to 399, you can see the marked paragraph 55. You can see it says, thirdly, the words entitled do not carry any special meaning specific to the statute. They're words of ordinary usage and should be given their ordinary meaning. But there are many references in the taxing statute to beneficial and beneficial ownership. But section 611 does not refer to beneficial entitlement, which it could have done if that meaning had been intended. And so it's concluded that the words are not intended to import the domestic law concept of beneficial interest or entitlement, and it's stated that the cases that I've mentioned aren't in assistance of assistance. So I need to show you that, and to answer it by saying that I respectfully disagree with that. And what I would say is it's just been put to me that the expression entitlement has a meaning which is consistent whether it's on its own or whether it's part of beneficial entitlement, and it is the right to an asset. It's the right to receive a thing. And the word beneficial, sorry to labour the point, simply says that it means for your own purpose, in your own right.
Forgive me, just for my note, because I was writing something at the time. What was the passage that you just read?
This was on page 399 of Good, paragraph 55.
And you were asking us to read the whole paragraph, or focusing on a particular?
I read as far as about just before C, just to the end of, just after C. If you'd like to read that.
Yes, thank you very much.
Thank you.
Sorry to be behind.
In this case, the taxpayer had assigned his right to the interest, but was still held to be entitled to it, right to the income?
I think it was a security assignment.
Is it? Yes, I was going to ask, so is it the fact that it was only assigned by way of security that is decisive? Because normally if you assign your right to something to someone else, you wouldn't be said to still have the right to it.
I agree with you.
I think it was a security assignment because I think the court rely on Archer and Miley and other cases that to that effect.
Go to paragraph 82.
Sorry?
So I think it was paragraph 82.
It's only paragraph 82. That's very helpful. Let me have a look at that. I'm sure you'll be right, but let me have a look. Yes, that, if I could take you to page 404, paragraph 82.
I think the point is emphasised more by Lord Justice Snowden. Lady Justice Whipple does, as I recall, rely on the fact that, in essence, Mr. Good benefits because the interest is discharging obligations he
Yes.
has to pay interest to the lender.
Yes.
I think that's at 62, is it?
Yeah,
Is that the same in Khan?
Yes.
yeah, there's some
He was entitled to sums that got him off the hook that he got onto.
well, yes, in Khan, the distribution allowed him to discharge his.
Yeah, so how does that compare with Humet's situation here?
Right.
Humet on the hook, and they then are entitled to something to get them off it.
What I would say is that let me just have a quick look at 62, which I have marked actually. This is on page 401. Yes, what I would say is that in these terms, the question was whether Mr. Good. Let me just get the exact wording so I don't get this wrong. Was whether he was entitled to the relevant payments, the minimum annual payments. He argued that he wasn't entitled to them because they were immediately paid away to discharge the interest. In relation to Humet, what we say is that Humet, on that basis, should equally be able to say, sorry, he was held to be, Mr. Good was held to be entitled in the situation of this case, because the sums, although they didn't make their way through his bank account, they went direct to the lender. It was still the case that he was entitled to them because they discharged his obligation to pay the interest. And so we say in Humet, there's a situation where the money was, as a matter of fact, received by Humet, albeit was immediately paid away as to 99% or more. We say that if Khan is, sorry, I beg your pardon, if Good is appropriate to say that there's an entitlement in a situation where there's been an attempted assignment, and the taxpayer can still be taxed on those sums that go directly from the purchaser of the film to the lender. It must be the case, even more strongly, that the taxpayer in our case, or sorry, Humet in our case, was entitled, and we say beneficially entitled because it was for its own use.
Just so, I appreciate you've explained this to us carefully and correctly, and I just want to make sure that I've understood it. Could you just walk
Yes.
me through the position from the perspective of Humet?
Yes.
Now, Humet is an existing company.
Yes.
Doing what?
I don't know. It's I
And
think it's business. Well, it's business, so called, is financial, but I don't know what turns on that.
and you might say it makes no difference, but the figures that
Yes.
Humet gives are pretty much the same as the figures that
Yes.
exist for the purpose of your client,
Yes.
give or take.
Yes.
Right, but leave that aside. That if start the clock where you will from Humet's point of view,
Yes.
and show us where the dial goes in terms of debit, reimbursement, credit,
Yes.
disbursement, or whatever.
Yes.
What are the steps from Humet's
Yes.
point of view?
Yes. From Humet's point of view, it enters into an agreement with a company called Storier. Storier having almost immediately beforehand acquired the right to capital and interest from in respect of a loan that was made to the appellants. So pausing there, Storier has the right to the capital and the interest.
So Storier has an asset.
Yes, the debt and interest on the debt.
Yes.
As effectively stepping into the shoes of the lender.
Yes.
So having done that, Storier then sells or assigns its right to the interest, which, I mean, may as well put some, from what I can remember that I showed you, roughly it was about £38,000. So
That was a sample.
yeah, it was a sample. It was made, the figures are much
Well,
more.
much bigger, but
yes,
let's take that for
yeah,
ease.
yeah. The figure probably 10 times that, whatever.
Yes.
But anyway, 38,000. So Humet enters into an agreement to buy the £38,000 worth of interest for, say, I'm making this up, 37,500, something like that. So the next day, or even the same day, the interest is then received by Humet. It receives £38,000 of interest, and it's obliged to pay the consideration to Storier for the assignment of that interest. So it pays 37,500 to Storier. And so it simply receives 38,000, pays 37,500, or possibly more. I mean, the figures may be higher, but it receives and immediately.
Right, but it doesn't. Until it receives £38,000, it has no obligations to anybody.
Well,
We
we
don't have
don't know.
We don't
that.
have the paperwork. No. We don't know.
There's certainly no finding.
There's no findings on that. No.
that,
That what we do, all
what-
that we
what-
have. So I beg your pardon.
There's no finding that what Hamet agreed to pay is the very sum it received, or only that sum, or anything.
The only thing that we have are the accounts, which for 1 year showed something in the region. Again, I can't remember the figure. Something like 2 million received. That figure less 500 paid out. Something like that. So that's what we have. And the at first instance, the Fist Tier Tribunal accepted that in that small margin, my example, £500, that would be said to be beneficially. There was beneficial entitlement to that because it was received and held. But what the Fist Tier Tribunal found was that there couldn't be beneficial entitlement in respect of sums that were received and paid away. And you will have seen that that was first of all, well, that was principally by reference to a case called the Maguckian case, which in the Upper Tribunal was held not to be relevant. So where we had got to was the good case at page 401, and we just read 62, paragraph 62. And what we're saying there is, as can be said, Lady Justice Whipple had said that she rejected the proposition the taxpayer completely alienated his rights in the maps. So it's no longer to be entitled. The fact this doesn't reflect the reality. The maps were assigned in parallel with the lender's obligation to use them to discharge the obligations under the loan. The taxpayer derived a clear benefit from them each time they were paid, while the loan remained outstanding, sufficient to mean that the taxpayer remained entitled. And so in our case, what we're saying is that in respect of the sums that were received by Humet and then paid away by way of consideration, there was entitlement to those sums, and there was a benefit because the sums were used to pay the consideration. So in that case, it wasn't just, it's reasonable to say there was entitlement in accordance with this case, and we say it's reasonable to say there was beneficial entitlement because the sums were received for
There's
their
a benefit to me if you give me £5 in order that I can pay you back.
Yes, I take the point.
£5.
I take the point. But it was if you look at the Indo Food case, you've got a situation where you've got a Netherlands company interposed between the Indonesian and Malaysian, and all it's doing is receiving interest and passing it on. I appreciate that the Court of Appeal it lost, but at first in the Chancery Division it was held that that was sufficient to give it beneficial entitlement. We would say it's the same here.
But there appears to be in these authorities, which everybody here is much more familiar with than I am, a continued return focus to the reality of what is going on, while having respect for the legal entities that take part. So, from Humet's point of view, what's the reality of what's going on?
From that point of view, you'd say that Humet's reality is that it has received interest, to which it's beneficially entitled, and discharge its obligation to pay for that amount. So it is, if you like, what at first instance it was held was, in respect of the very small quotes profit, they can accept that's been beneficially
It's an
entitled.
admin fee type.
Sorry.
Is it the administrative fee type aspect?
I suspect it was something like that. Or it might just have been to give a turn. I don't know.
Okay.
Yeah, but we don't know.
There was a clear finding that from the point of view of your clients, this was all tax motivated, and I understand
Yes.
that's a factor, but not a conclusion. But what if any findings were made or needed to be made about what Humet?
Well, I think what
There's no indication that there was anything commercial going on.
no, I don't think there is. No.
But there may not be a finding that there wasn't.
No. I think we are where we are with those findings, with apologies. Yeah, I think.
Thank you.
Sorry.
Just my learner's friend's got a
Sorry. Well, no, it is covered in the FTT decision at 140 to 142.
146.
140 to 142.
Yeah, let me just have a look.
So this is what was it on the where the
This is the
little
core
amount.
amount. I think it's paragraphs. Is that?
Yeah.
Thank you. I'll find the
Page
page.
129.
Page 129. Thank you.
Thank you very much.
Yes, would you like to read 141 and 142 in the core bundle on page 129?
Well, 140 is relevant too.
Sorry, 140.
140.
Thank you very much.
So if I can just, we're still in the good case, if we can just take you to page 408. And I'm looking at the marked paragraph 110. And what's being said here is, as you can see, paragraph 110, this is Lady Justice King. As discussed by Lady Justice Whipple at those paragraphs, I agree that the proper approach is to apply the ordinary meaning to the words entitled to in section 611. When such approach is taken to the interpreted section, it is clear that a person can be held accountable to tax on payments which have been made to a third party if that person benefits from those payments. And the point about that is again in relation to whom it did receive those sums in question, and albeit that it paid the vast majority away, it should still, in my submission, be treated as entitled to those payments by reference to the rationale from this case, beneficially entitled, because it was falls within the meaning of beneficial entitlement on the basis that was its interest to do with as it wished, and the fact that it was contractually obliged to pay the sums away, or did, does not affect beneficial entitlement. I should now take you to the McNiven case, which is McNiven and Westmoreland. Sorry, tab 13, page 136. Again, I think this case is probably quite well known, but just to quickly rehearse the facts. You can see that the appellant, or the parties include Westmoreland Investments Limited. Westmoreland Investments Limited was a company owned by a parent company, and that parent company was in turn owned by a pension scheme, which was the electrical supply pension scheme. So what you have is you have a situation where the pension scheme is the indirect owner. That's not the relevant point for this, by the way. Indirect owner of Westmoreland. Over time, Westmoreland had made a number of investments which had not gone well, and it had losses of about, or it owed about, I should say not losses, it owed about £70 million, of which importantly £40 million was in the form of interest. Excuse me. At that time, if you had a company such as Westmoreland, you could sell it to a third party, provided it had losses that the third party could access by grouping the company into the purchasers group. So the question was whether you could make Westmoreland an attractive target with attractive losses. The difficulty was that the £40 million of interest that it hadn't paid the amounts of interest. And in order to offset the amount of the interest in question to produce a loss, it had to be more than owed, it had to be paid. So the question was whether you could actually pay £40 million of interest to create a deduction. And the only entity that could assist was the pension scheme. And the pension scheme over time lent £40 million to Westmoreland, which was immediately used by being paid straight back to Westmoreland, to whom it owed interest in the first place. So you've got a situation where the company owes the pension scheme interest but hasn't paid it. In order to pay it, the pension scheme lends the amount of money, and then that amount of money is paid back up to Westmoreland.
Sorry, to Westmoreland, you mean the parent?
So I beg your pardon, to the pension scheme, thank you.
So the parent is not relevant? It's
No,
just...
it's,
Oh, okay.
beg your pardon. No, it's effectively, you could ignore that, I'm sorry. You've got Westmoreland, and then it effectively owns the shares in the underlying company. So the pension scheme effectively owns the company in Westmoreland through a parent company. And the question was simply, if Westmoreland needs to make payments of interest, can it do that? And the only way it could do that was to receive more loans from Westmoreland and to use those sums to pay the interest back up to the pension scheme in respect of the long-standing interest that was outstanding but hadn't been paid. So
does that mean it just replaced an interest obligation with an obligation to repay capital?
I think what it meant was the money just went round in a circle, actually. So I think if it owed £40 million of interest, it would, I don't know what it did to the capital in question, I don't know. It just lent the money. And then
It has to borrow 40 million from the SPS.
Yes,
pays 40 million as interest to ESPS,
yes, yes.
but it's presumably now got a capital
Yes,
liability
yes.
for 40 million to
I
ESPS.
assume so, but that doesn't seem to affect the ability to set it off as a company with valuable losses. I think that's right. I could check if that's right. So the question there was simply when you've got money which comes down from ESPS, from the pension scheme, to Westmoreland and goes straight back again, so that Westmoreland can make the payment. Has Westmoreland actually paid interest at all, given the circularity of the arrangements? And if you look at the page 136, you can see 2 or 3 lines up from H. Actually, it might be worth just reading the whole of that piece that just says held, actually, at the bottom of page 136.
Thank you.
The key, yeah, I mean, for your note, there's a reference to I'm not going to repeat it, but it's a paragraph 67. There's quite a helpful discussion there as to what payment means. But you can see that what's being said here is that there's the notion of a legal concept, being the payment of interest is a legal concept, meaning the simple discharge of a debt, and that to some extent commercial expressions and I would say legal concepts have a special status in terms of this purposive approach. And that what we would say is the expression beneficial entitlement, which has been used in the
Quite a long way
different cases.
away. I mean, payment of a debt is quite a long way away from the sorts of terms that we're construing, isn't it?
What I would say is that it's what I would say is that it's almost like, as we've seen, a term of art. We've seen it being stated elsewhere. It's almost like a term of art. So what I would say, perhaps it's not a legal concept, but that it's got a special status, which, as we'll see from one of the cases we're going to look at in a minute, I think justifies having a consistent meaning rather than a meaning which depends on the surrounding circumstances.
That's a bit in tension with what was said in Good, where I think Lady Justice Ripple and Lady Justice King both said it doesn't have a technical meaning. Admittedly, that was entitlement, not
Yes.
beneficial entitlement.
I just didn't hear that. So they didn't.
They both said
It just had ordinary usage. Yes.
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 So not to be given a special term of art
Yes. What
technical meaning.
Yes. What I would say is that the beneficial entitlement should be given a special meaning because it's for the reasons that I've mentioned before by reference to those cases, and that what we've got here with entitlement is not something that is such an expression that, if you like, has such substance, but that if you're therefore there's twofold arguments. Number one, entitlement goes within the expression entitlement within those cases, Good and Khan, tells you the meaning of entitlement within that, which doesn't go against the meaning of beneficial entitlement, which we've seen. And what I would say is beneficial entitlement is an expression which should not have a different meaning from time to time, given that it's almost a term of art that has been analysed in the way I've described it in the various cases.
So entitlement is not a technical term, but beneficial entitlement is.
I would say so, because it's simply because beneficial entitlement has been discussed in those cases, and we've seen in, I think, wood preservation that beneficial ownership was described as virtually a term of art. So that's why I would say it has a special meaning.
Does it matter that wood preservation and Sainsbury's and so on predate Ramsey and before the purposive approach to
Well,
text
what I would
statutes?
say is it means that we've got to juggle the two. I think what I would say is there are certain expressions, beneficial entitlement being one of them, which have to be looked at carefully in the light of the purposive approach. And the purpose of citizens are entitled to know what the words mean, obviously, and I would say that it's important that beneficial entitlement has a consistent meaning. And in the situations that we're looking at, that consistent meaning should be retained. That's what I'm saying. Yeah.
Well,
Thank you.
Sainsbury, of course, well postdates Ramsey.
Yes.
Um,
Yes.
Yes, thank you.
Considers and applies with preservation. Isn't it?
Yes.
Well, and certainly considers. it.
Yes. Thank you. That's helpful.
Now, how are we getting on?
The ground two is very short.
All right.
I mean,
So long as you're happy with that.
I doubt it's
The question
more
is
than
whether you're
more
happy
than-
with how you're
I
getting.
shouldn't think it's more than 20 minutes. So, yeah,
Good.
I'm
Thank you.
aware I've got learned friend needs to get to his feet. Thank you. So let me just see where we've got to. So, if I could take you to page 157. The bottom of page 157 looks at the McGuckian case. I wasn't proposing to mention that because it's per se, because it was held in the Upper Tribunal in relation to this Hargreaves appeal, but it was after all not relevant. But I just wanted to show you pieces from Lord Huffman's discussion in relation to the McGuckian case. Missing a lot out, McGuckian can be condensed to the following facts. You had a situation where a distribution was going to be paid. I'm going to get this slightly wrong, but it doesn't matter in terms for today. A distribution was to be paid from a company. By various steps, the shares in the company were moved into trust, as far as I remember it. But the important point was that the right to the distribution was sold for a capital price. So the question for the court in McGuckian was, if you have a distribution which makes its way to the recipient, and then a purchase price is paid, whether you've actually received the distribution or whether you've received a capital payment is really the point. And it was held in that situation that you couldn't say that there was a capital payment, that under the terms of Ramsey, that effectively the distribution had been received, albeit disguised as capital, had been received as income. I don't think we need to know more than that, but he will explain what I'm just about to take you to. If you look at page 158, if you look at towards the bottom of paragraph 54, two or three lines below F, this is Lord Hoffman explaining how he thinks this approach, the purposive approach, Ramsey approach, applies. So 3 lines below F, but the transaction in the McGuckian case was nothing more than an attempt to relabel a sum of money. The fact that the sum had no commercial purpose did not mean that it had to be disregarded. So just to stop you there, the fact that it had no commercial purpose didn't mean it could be disregarded. But it failed to perform the alchemy of transforming the receipt of a dividend from the company into the receipt of a capital sum from someone else. For the purpose of the fiscal concept of state, namely the character of the receipt as income derived from the company, made no difference. So what I'm saying is that the fact that an assignment has no commercial purpose doesn't mean it has to be disregarded. So the fact that our steps have no commercial purpose doesn't mean they have to be disregarded. If I then take you over the page, and again, we've just halfway down page 159, you've got the limits of Ramsey. And I've made this point about taxing statutes often referred to, this is in the middle, sorry, of paragraph 58 against marginal F. Taxing statutes often refer to purely legal concepts. Now I take the point that beneficial is not a legal concept, but what I would say, it falls into the category of virtually a term of art or an expression that should have a consistent meaning regardless. And so what I'm saying is it should, that Ramsey does have limits, and that if you have a situation where you have an expression that has long been understood, one should be reluctant to change the meaning of that expression just for this one particular case.
Yes, I mean, Lord Hoffman's distinction between legal and commercial concepts hasn't, just to avoid Mr. Bennett having to answer the point, hasn't necessarily been favoured.
No, I agree with you.
in subsequent
I agree with you.
decisions.
I agree with you. It's that's a fair point. That it is still
Well,
here.
Niven certainly hasn't been
Yes,
part of
no, but it's here. I take your point. Right. So just to finish off this first ground, if I could just take you to tab 22. This is a non-tax case. So, sorry, page 353. I don't think we even need to know the facts of this, to be frank. It's a case involving nationality and British citizenship. The point I want to make is it is helpful in terms of dealing with the construction of statutes. So if I could ask you to turn to page 369. Could I ask you to read on page 369, paragraphs 28 and 29?
Thank you.
Thank you. The point to make about that is just the one I've just made, which is that in my submission, words that are expressions that are well known and well used and have, as I said before, become virtually terms of art, should, where possible, retain their meaning, and one should be reluctant to change the meaning by reference to the particular
In
circumstances.
particular, they should mean the same whether you're talking about the taxpayer as the beneficial owner of something, or a third party as being the beneficial owner of something.
Yes, yes. And that more or less completes my submissions on ground one, but by way of summary, it's plain in my submission that the expression beneficial entitlement should be given its domestic meaning. That's the Indo-Food case. In my view, should be considered by reference to the main cases which I took the court to, IS, Wood Preservation, Sainsbury and Bupa, and that the cases of Khan and Good, which talk about the meaning of entitlement, which give a wide meaning of the word entitlement, are helpful to the appellant in terms of widening or explaining how wide the expression beneficial entitlement goes. And those complete my submissions on ground one. Right, I've just been asked if I'm going to do this case of Clipperton, and the just Clipperton, which is the behind.
Only if you rely on it.
What I felt was that it talks about Khan, and I'm sure my learned friend will take you to it. But from my point of view, I did not feel that it added or lessened my submissions. But no doubt my learned friend will make some points. If you'd like me to do it, I will do it.
No, you will have the right of reply.
Thank
It's
you.
entirely up to you whether you want to rely on it now.
Literally asked for it to be in the bundle.
Oh, let me explain the background to this. Let me explain, because I'm not trying. I think my learned friend thinks I'm doing a trick on him, which I'm certainly not. This, if I could I take you to tab 24, page 409.
Yes.
You can see the case was handed down on 29th of February, and I simply said to my learned friend, look, this case has to do with Khan, and it's a Court of Appeal case. I think it should go in the bundle, we should consider it. In fact, I've marked it all up, to, as you can see, but in the end, when I was reading it through, I thought it was not particularly, it wasn't particularly helpful either way, so it is.
It's a very, very unhelpful case.
Pardon?
A very unhelpful case.
I don't think it's unhelpful or helpful, to be honest. I mean, my learned friend, I really don't. I'm very happy to show you the bits that I've taken.
Incredibly perspicacious, even if unhelpful in this instance. I'm sure it's what my learned
No,
friend needs.
I honestly, I'm not the sort of person. I mean, when I started as a barrister, somebody sent me the night before a case to read, which is 2,000 pages long on traffic accidents. I would never do that. I just genuinely thought it should be in the bundle. So my apologies if my learned friend has spent ages reading it. That wasn't my intention.
All right. Well, if anybody, or indeed my lord, minds something out of that, we'll consider it.
Yeah.
In
Okay.
due course.
Would you like me to start ground two, or would you like to take a break and come back at quarter
No.
to?
Well, if you're able to,
Yep.
I say it's a 20-minute.
Well, it probably isn't, but it feels about 20 minutes. Yes.
All right. Well,
It's
clearly a much
It's-
crisper point.
Yes, I mean, in many ways, it doesn't really need much to be said about it, actually. So let me just. I don't need to take you back to section 874.
No.
Section 874. We're talking about yearly interest. So the question is whether we have yearly interest.
And this applies to only some of these.
Yes, I should have said.
I didn't get a clear view of roughly what amount or percent of the payments.
Actually, do we know how many loans it is roughly we're talking about? I think it might be 30. Is that right? It's about 30 loans, I think.
About 30% of them.
Is it 30%? We'll find out. Sorry.
Right. So we've got your skeleton argument on that. Where would you like to go?
Right. Sorry. This is fine.
For my note, your skeleton argument starts on this para 77.
We'll find out what the percentage is. But if I could just take you to the core bundle.
Thank you.
This is the First Tier Tribunal's decision behind tab 9, page 116.
Yes. And we
So
start.
what this question has to do with, as we know, is whether there's yearly interest, and it's in the context of there being a series of loans that were brought to an end physically, I should say. That it's up for grabs. So it's for debate whether that satisfies.
This is a challenge to what's it called, a multifactorial evaluation, is it?
Yes, yes, and just to make it clear that below we argue that you could actually say that loans that extended beyond a year might be treated as not producing yearly interest, but we're not running that up.
You've retreated to within the year, have you?
Yes, absolutely. So all of these loans, if I can put this sort of neutrally, as a matter of fact, and not the debate is whether it's a matter of law, but as a matter of fact, came to an end within 1 year, so before the year end. So the question is whether loans that are brought to an end can produce yearly interest if very soon afterwards similar loans are made. And
Well,
that's
we'd be grateful if you could, at some convenient point between you, just identify what the amounts and then
Yes.
and therefore what the percentage
Yes.
of those ones on which you're now focusing.
Yes, but I'll do that.
Thank you.
And that relative to whom-et?
To
To whom-et? Because I perceive that there is presumably an overlap.
I think there must be, yes. I hadn't thought of that. I think there is, yes.
Okay, if you could
Yes,
proceed
yes,
now. Then
Yes,
maybe.
thank you. So the starting point is to look at the core bundle behind tab 9, page 116, and we're looking at paragraph 78. So page 116, paragraph 78. Yeah, and you can see that paragraph 78, the judge at the Fist Tier Tribunal agrees that the loans fulfil an important commercial need. JH is John Hazelwood, the finance director, noted they're unsecured, leaving the assets of the appellant unencumbered, available to stand as security for other financing raised. The lenders were connected so that the loans could be documented easily, didn't involve any of the usual front-end cost arrangements that the appellant needed to incur in raising finance, could be raised quickly. And so then you have this para 79, determining the purpose of the appellant and the relevant lender and entering into each of the loans a question of fact. In considering that question in relation to the loans which the appellant alleged to have been given rise to short interest in the case, I've taken into account the fact that such loan was repayable on demand and was in fact repaid within or very shortly after the period of a year from the date it was advanced. Then we come to the first point. However, I'm mindful of the injunction in Gosling's, I'll take you to Gosling's, to adopt a business-like approach instead of a dry legal assessment of the documents when it comes to determining the purpose of the parties to the loan. And then got a reference to the Special Commission in the Mincham case. You can see, and then at the top of page 26, you need to stand back and take an objective view. And then I'm forced to the conclusion that despite the regular annual payments of the loans made by each lender, the loans made by that lender were intended to form part of a longer-term funding of the appellant and were regarded as an investment, albeit an unsecured investment. I will just go to this point, but one of the points to make is that when there is a reference taken from Gosling's to apply a business-like approach, what we would say that is to do with the situation where, in relation to a single loan, not a series of loans, a single loan, you need to step back and ask yourself whether that loan is or isn't one producing yearly interest. And in that particular case, this was all to do with mortgages, which we all know with a mortgage, there's an equity of redemption after 6 months. That no business person applying a business approach would say that a mortgage is likely to be a 6-month loan. So in our submission, the business-like approach is limited to looking at the particular terms of a loan and not by reference to this situation where there's a whole series of loans. That's the first point to make.
Paragraph 79 is the concluding part of that is taking an objective view as the test, a finding of fact.
What I would say is he's applying a business-like approach.
Yes, but the loans were intended to form part of longer-term funding.
Yes, don't deny that. No. Yes, what I'm saying is that if you apply the Gosling's case to that approach, then you should do it carefully in my submission, because Gosling's was looking at one particular loan and applying a business-like approach in relation to that one loan. I am saying you can't apply a business-like, in my submission, you can't apply a business-like approach to say that loans that are, as a matter of fact, are separate should be treated as producing effectively loans that run on for more than 1 year. That in essence is our
Let me get
submission.
that clear, because you're not disputing that the individual loans formed part of longer term funding.
I'm not disputing that one.
Right, well then, so that's a finding of fact, which you're not disputing. What are you seeking to do? Say that that's not either the test or not relevant?
I'm saying that I'm saying that's not the test. I'm saying that when you're determining whether loan number 1, which ends within a year, and then followed by loan number 2 and loan number 3, whether you can say, looking at loan number 1, because I know it's going to be replaced by loan 2 and then loan 3, therefore I can say there's yearly interest in respect of loan 1. I'm saying there's no authority for that.
But you're saying that you have to look at loan 1 in isolation?
Yes. As a matter of law, that's what I'm saying, yes.
Right. So, right.
It might be helpful if I take you to page 119 of this decision. If you look at paragraphs 89 to 91, might be, if you'd like to read those. Before you do, I'm not asking you to read the 3rd point, because that point's not being made. So it's paragraphs 89 to 91.
Yes.
So the main point which I've just made is in relation to the end of paragraph 90, about 6 lines up. The fact that each loan had an independent existence and was repaid after a period of approximately 1 year does not mean that each loan should be viewed in isolation and with blinkers.
So that's what you challenge?
Yes, that's what I disagree with, yeah. And if I could just take you to the Lehman case, which I'll just find. That's in the authorities bundle, tab 20, starting to read at 317. I'll just find it. If you actually, I've said it starts at 317. It starts at 315.
Yes.
But 317, I've just marked up one of the paragraphs there, and just quickly, this is a case involving interest that's paid following administration, and again, I'm sure the case is familiar. So the question is, if the administration takes some years to ensue, and then finally you get to the stage where interest is to be paid, do you say the interest is, we're looking to see whether that interest is yearly? Do you start with the end of the administration or beginning? That doesn't affect us, but it just is the background to this case. If you then turn to page 321, I will just quickly go through some of these points. So you can see page 321 has marking in the margin. I think the quickest thing for me to do, because I think everyone, this is fairly well-trodden ground. If you look at paragraph 21, that's the first case, which is a key case, which is Bebb against Bunny, Bebb and Bunny. And you can see that what this is talking about is how you ascertain yearly interest. And I don't know whether you'd like to read paragraph 21 to the end. That would probably be the most sensible thing. To the end of 21.
Does it follow from Beb and Bunny that money paid on for late completion, even if it's in fact outstanding for less than a year, is still yearly interest?
No, if we go over the page, it's the Bev and Bunny is dealt with in that that circumstance, from what I remember.
Thank you.
In fact, the simplest thing I think is the only point I wanted to make here was this point about the mortgage interest, which is that for the reasons I've mentioned, mortgage interest may not be a good example because everybody accepts that mortgage interest is going to run on for quite some time. So if you could turn to over the page 322. I don't know whether the simplest thing is if you just read the pieces that are marked. I'm sorry, it's quite a lot, but it's probably the quickest way of doing it. Those marked paragraphs.
Yes.
And then I think that the main, perhaps the most helpful thing to go to is towards the end of page 323, because then you get the key tests known as the Hay tests. Various passages are marked, but it'd be sensible to go to paragraph 30, and one just needs to read paragraph 30. Probably to the end of the marking, so from paragraph 30 to the halfway through 32.
Yes. No, would that
I've just about finished
don't want
my...
to rush this, so
No, I think I'll be 2 more minutes actually on this, so that's my submission.
well, if you're happy, you can have this good reason.
It just
If
seems
it's more
sensible.
convenient to get to the end of it, please do.
Yes, I think that what I'd like to do, just to focus on the Hay test, which are at the bottom of 323. So you can see there's paragraph 30, and then at the bottom of page 32 there's an indent. If you just take these tests and you apply them in our situation, the first is that interest paid in respect of a short loan is not yearly interest. That seems fairly obvious. The question is whether we have a short loan or not. We obviously submit that we have a series of short loans. Second, that in order that interest payable may be held to be yearly interest in the sense of the income tax, the loan in respect to which interest paid must have a measure of permanence. So you can see that's for, well, my learned friend and I are going to disagree. We're going to, my view is each loan is separate, and you should look at each loan, and there's no law that says you treat one loan as eliding with another because it's replaced with another. The third is the loan must be of the nature that the loan must be of the nature of an investment. I think it's accepted that they, in this case, they did see them as some form of investment. The loan must not be one repayable on demand. These loans were repayable on demand. The loan must have a tract of future time. And again, that's back to the same point, which is that taken separately, I would say that the loans didn't have a tract of future time, but if they're put together, then they do. But my submission is there's no law for saying that you take consecutive loans and treat them as one. And I think that's really all I need to say on the point.
Is that it?
That's it, yes,
Well,
thank you.
it's been very, very helpful. Thank you very much indeed, Mr. Wade.
Thank you.
All right. Well, if it's convenient, we'll hear you at 2 o'clock, Mr. Howard.